petition ane ye na Supreme Court no uphold the amano na say one sum na obotugu ya from petition ane side almost determined no as a miscarriage of justice no it wasn't right.
Me pacho, how is that a miscarriage of justice? Me pacho, the me pacho, you see, I was here careful, said a no so enquire contempt of court. Because don't forget the review application is pending before the Supreme Court. And looking at me share that I'm breaking it down. So, say elections in a documentary. You participated at the polling station. You participated at the collation center. At the national a friend is saying stage, so it was easy for can be a friend strong room, no, and also now were representatives were about what I say. The results are
what do you mean, Chawan Wadam? I'm saying at him for the room. It's young couldn't go to Yombeka. Say, you now see about how I was about Chedium. Lawyer and now AJ Bafo and your training kind of petrol so DBS roofing and now quite Mr. Madam and the Supreme Court. A year is a election petition 2020, bro. Young couldn't go to the costume.
For your indulgence. We are grateful to the court. We're grateful. Rise.
For the Supreme Court in hearing that election petition brought to it by the NDC's John Dramani Mahama. Sitting will resume on Thursday, but earlier the court went on recess to decide what happened next in regards to Mr. Mahama's team refusing to obey its order to file witness statements and legal arguments relating to the initial objection. And you will recall that Mr. Mahama's team wanted the hearing to be put on.
I don't think yasa babiem na yebowura Supreme Court sisi e na chese atemwafo no ekwohye dan mu a omobae no wonmo atu asem no ahyeda nyame adoma da ya wada January bosumi ndeto so aduonu nwotwe 28 January na asem no ombesi aginaye si ekobenkum ana yekonifa se meka say de wonmo atu asem no de akwakohye nyame adoma eda ya wada ayere se benta na enche bia emranimfo a omugina mu edema afanu ana na mpempi no petitioner no any second respondent no one mo lawyers na eta address press no enche omobone ensentrofo bekasa ye bakakofa na kai se yewie ye court nsem no ana ye tu ahyeda no a enyame pa ebesan akọ ye flight lieutenant General John Rollins na yiyo nase na ye de akaso atoa so eja ebo baako ne edi ekum no mamienu nsem mienu nyina ye nsem akese a ewose ma hu sunsanso wadom TV so nti na ye de ema wo petrol ope clean fuel ye de ma in full quantity ye can clean fuel it say fa ho ne mfa bibia mfrefre mu in full quantity na say pump no so di bua ma ne ndwoso no what you say enti na die ewo mu eno no na aboafo yi naja brano ma yitimi ehunu die ekoso wo court DBS Industries ene ebase ye modern so emfa nchese papa modern so a Ghana how many tipen adwuma ni ti was painters papa restaurant nchen ho nkrabata ndo so kokumasi dakwadwom bekosunyane takrade tamale DBS omudi aheta ba bia color link plus color opani de try ho nchense ama finhia duonu a chese ye no wato nchia se ho guzu nkrabra eno ne 20 year warranty na ye ka ho asem no dan so a wo de board down so emu nyunyu nsu beto ehum betum frama befa na nchense ne tse de tie DBS nchense tini aka cho se no ne papa no kwa mixture immune system no ebema no agina ne na so yie so immune system no wa hoden a den se koro betima ka wato fom ati ase na ade ba ko ma immune system ne gina so yie na se dro ba ko a edi widie no mu akagina mu ma nkwam wewo mu no nya hoden no eye kwa mixture say for your general well-being ene ahoden de onya bokwa mixture nko de awunim se wo bi wo widie no se de water polytank na wo nsu temu no sa pepe eno ahoden no so eta widie no de ma se nyimekoi adaroma na ye de ekoso court ebrewo se de meka ye no enchemranimfo no ene sentrefo be kasa no ma chirichiri mo mo ntia se wo de akoso court ne no na de yomu ne se ene court no ensi agina ye bia ese mpo ye wa de srede a eye petition a on penda da John Dramani Mahama e de baaye ana sempo ensemfo a court no oda ya na o share so no mfamra ebi de wom de koye ebi amfomo de anko na no de wansi hu agina ye ne nyame ya adom da ya wada 28 January na kwan bi aso no court no ekire mu a obebu asa asem no mia na me bom paye se asem ne bi to ahyeda sanse se court asem no ho na e mampeni dada rolling se yie no so enam nchen a esa ya ne hadwene kakra na ama yenya divided attention yie no na me adoma wo kina e wa kokoro peni no na chese ya prepare na afi yani ba akọ aka no ya hwe na ye de esi court asem no so na bibia akọ kama enkonko esasi yesu ne ani etempumam ehwe yankonko tie lawyer Frank Davis a ono oka emeranimfo ejina ma na nado danko akufo ado no
was for the petitioner. You will recall that on the last date of court, that is the 20th of January, the court made definite orders complied with by all lawyers in the case, lawyers for petitioner, lawyers for first respondent, and lawyers for second respondent. The petitioner was his witness statements by the 21st of January 2021. First and second respondents filed their witness statements on the 22nd of January 2021, incorporated with their submissions on the preliminary objection to have the petition dismissed for disclosing no reasonable cause of action. As was to be expected, the petitioner flatly decided to disobey the orders of the court and was openly defiant even this morning. I must say that as practitioners of the Supreme Court and as lawyers who attend to courts regularly, we need to exercise a little bit of restraint in the choice of our language. It's very important because at all material times we are officers of the court. It's unfortunate the language used by my good friend Tony Lita this morning, it was a bit offensive to say that an application before the court has been predetermined. To say the very least, rather unfortunate, coming from my good friend, of course, and a very senior member of the bar. Well, the court did not take kindly to that. As it is now, the court has been gracious and very lenient to the petitioner because they've been given another opportunity to rectify the wrong. The petitioner has been ordered to file his witness statements by close of day tomorrow, which is Wednesday. The petition has been adjourned to the 28th of January for hearing, which is Thursday. Now I must say something. We are legal practitioners. The Supreme Court is a very busy place. The Supreme Court is not a forum for organized, rehearsed, and choreographed theatricals or melodrama. It's a place for real, hard, and serious legal work. It's not for flurry of literature, long prose, and rather dull English, devoid of any legal merit. I want to advise my colleagues on the other side that if it ain't broken, don't attempt to fix it. We are ready for them on Thursday. Thank you.
The petitioners at every material time have said that every person they have filed is within their remit and within the law. We found about four applications. What's the process? What do you think this needs to move on before we move to the next stage?
No lawyer has an unfettered right to say that any application he or she files is within his remit. That is why we have the law laws. You don't come to court with the preconceived notion of what you think you have filed. The court at all material times is governed by rules, and the court applies these rules to the letter. They have no unfettered right to come to the court with the needless and unnecessary applications they are filing. You, in one breath, you don't want to obey the court. If you were in court, you should have listened to what I just said. You are coming to court for a discretionary remedy. You have been ordered to file a witness statement. You claim you have filed stay of proceedings, so you disobey the orders of the court. Yet, you file an application as late as yesterday, and you want the court to entertain it. That is not what trained lawyers are taught to do. If you disobey the orders of the court, it comes with these consequences. The court has given them the last opportunity. Let us see what they will do.
You had made a point that you wanted the case to be dealt with expeditiously. This development takes away some 2 or 3 days from the whole proceedings in terms of the build up to the court. We should be on concern.
Do you want to blame it on us? The one who brought the petition is delaying the trial. What can we do as lawyers on the other side? They are screaming that justice is being sacrificed on the altar of expedition. By their conduct this morning, do you think they want this case to be heard rather hurriedly? Don't blame it on us. When they come, ask them questions. Don't blame this on us. When they come, they'll be here soon. You ask them questions. We are trying as much as we can to comply with the orders of the court and make sure that this petition is heard within the 42-day remit that has been set by CI 99.
From the submission of Mr. Chikata following the decision of the court, one could sense some remorse that the court has misunderstood their intention. Do you still think that this is part of some deliberate design to delay the case, or you think that genuinely they misunderstood what the operation of the action should have been?
Well, my guess will not be as good as yours, but all I can say, I cannot interpret Mr. Chachikata's demeanor in court this morning, whether he has showed remorse or not. All I can say is that he has obliged the court that they will comply with the orders of the court, and we come to court on the 27th. Whatever they think they are doing is their baby, it's not mine. If they want this petition to be heard, it will be heard. But the court has warned them that CR 99 has its own rules, and that if you fail to obey the dictates of CR 99, your petition can and would be struck out. That should be instructive to them.
Thank you, Councillor.
Thank you.
Very much.
Thank you.